Good evening, and welcome to the African American Workshop and Lecture Series for our Fall 2021 session. We thank you most sincerely for joining us tonight for a wonderful presentation in the University of Oregon's African American Workshop and Lecture Series. And as you will recall, the series was one of the 13 demands of the Black Student Task Force, and the purpose of this series is to facilitate a better understanding of and appreciation for the vast contributions that Black people have made to our country and our world. Now, tonight's speaker is Emerson Sykes, who has written and spoken widely about the First Amendment, a theme that is near and dear to our hearts. But without further ado, please join me in welcoming Provost and Senior Vice President Patrick Phillips, who will introduce our speaker. Patrick?
Thank you so much, Vice President Alex Ascento, and thanks to everyone in the Division of Equity Inclusion for helping to organize this very important series. As I was talking to Emerson earlier today, I've really been proud of the work that we've done through the speaker series. I think it has helped serve as a focal point for really focusing a lot of our important conversations on campus around many topics, but of course, especially those regarding race and the relationship of race and the university and our role in society. And I think tonight's topic is perhaps a perfect exemplar of what that means, because free speech is really at the heart of what the modern university is about, and of course, is the heart of the modern democracy. And as a public research university, the University of Oregon owes a great debt to the society in which we exist, but we also are called to service to that society, to serve as a focal point and a clarification engine for what free speech can look like. And I think that those are difficult topics, they're important topics, and universities are frequently the test bed of understanding what that looks like. So without further ado, let me introduce Mr. Emerson Sykes. He's a staff attorney at the American Civil Liberties Union with the ACLU Speech, Privacy, and Technology Project. He focuses on First Amendment free speech protections and works on civil liberties and human rights at the local, national, and international levels. Formerly, Mr. Sykes was the legal advisor for Africa at the International Center for Not-for-Profit Law, the ICNL. He holds a JD from the New York University School of Law and a Master of Public Affairs degree from Princeton School of Public and International Affairs. And we really could not be more excited. We've worked him very hard today. That may come up today. Hopefully it won't come up in the form of extreme fatigue. But I know that he's been engaging with a lot of different audiences. We are grateful for that, for your participation, but we are exceptionally excited to hear what you have to say to us this evening.
Thank you so much, Provost. It was a long day, but I thank you very much for the invitation. I wish I could only have been there in person. I'm here in New York. I'm in our offices. It's getting to be late at night here. And as Patrick mentioned, I was on, I think, 6 different Zooms with different folks on campus. I wish it could have been over lunch and dinner and in cafes and in the plaza. But it's really a pleasure to be with you, especially thanks to Yvette, Alex Ascenso, and her team for the invitation and for setting up so much for my visit. So I'm going to go ahead. I'm going to do my best to use a little bit of technology. And give you what I call the case for free speech and racial justice. And I want to be explicit about what I'm trying to do here is provide support for Black student activism on campus. And the way I want to do that is by starting with a story about the other U of O. So I know where I am. I understand that I'm at least virtually at the University of Oregon. But just last week, we filed a case in Oklahoma, the University of Oklahoma. It's confusing. It's actually called University of Oklahoma, but they call it OU. Anyway, you probably knew that. I just learned that. Here is our client, the Black Emergency Response Team, one of our clients. We represent several clients. Black Emergency Response Team is a student group at Oklahoma. They have been active for the last few years in response to several different incidents on campus. They made a list of demands. They held protests. They did sit-ins. They did advocacy at every level of campus leadership. This may sound familiar to those of you at Oregon. I want to give a special thanks to the Black Student Task Force, without whom this lecture series would not be possible. But you might recognize kin in the Black Emergency Response Team at Oklahoma. And so these young student activists were so powerful and so successful in their advocacy that the state legislature passed a law to try to silence them. This law is called HB 1775. It's one of many, many, many laws that have been introduced across the country to prohibit inclusive education. You've probably heard them referred to as critical race theory bans. I mean, they don't talk about actual critical race theory, so we don't describe them that way, but it is an issue that has been sweeping across the country in state legislatures, in local school districts, at school board meetings. I'm sure you've seen the news. I understand it's happening very close by to Eugene as well. So they passed a law in Oklahoma trying to silence student activists and trying to silence discussion of race and sex in pre-K to 12 education. And so we filed the first federal lawsuit to try to block this law and try to stop this momentum in its tracks. These laws have been spreading over the last year or so, and we want to make sure that we can use the one tool in our arsenal, which is litigation, to try to block that. And I'm an attorney, so forgive me, there will be a few slides around analyzing a law. But let's just look for a second at HB 1775. Again, this law, in many ways and explicitly on the floor of the Senate, was intended to try to claw back the progress that the Black Emergency Response Team and other student activist groups had made. So the law prohibits any, quote, orientation or requirement that presents any form of race or sex stereotyping or bias in Oklahoma public colleges and universities. So if we look at that just for a second, it prohibits any orientation or requirement. So here, Black Emergency Response Team demanded that there should be a requirement of a diversity course for all incoming freshmen so that you could establish community norms and ensure that there were not repeats of some of the racist incidents that they had seen and experienced on campus. So this language around orientation or requirement is not by accident. It is directly targeting one of the specific demands of the Black Emergency Response Team. So they're trying to prohibit any orientation or requirement that presents any form of race or sex stereotyping or bias. Now, on first read, you might say, oh, well, that's just saying you can't be racist or biased. But that's not actually what it says. It says you can't talk about racial or sex stereotypes or bias. And it really shows the real underlying logic of many of these laws, which is the way that we're going to battle racism and sexism is to not talk about racism or sexism. And of course, we know that's not how it works. We don't overcome these things by avoiding talking about them, especially in public colleges and universities, where we want ideas to flourish and we want education to be as wide open and inclusive as possible. So this law, not all the laws that are sort of countering inclusive education cover higher education. Many states, it just covers K-12 or it just covers government employees. But in Oklahoma, it covers higher education as well as K-12 education. And it has a list of 8 prohibited concepts for primary and secondary schools. And this list of 8 prohibited concepts is taken directly from a Trump executive order that he passed before he was booted out of office, and which has since been struck down by a federal court as being impermissibly vague and viewpoint-based. But these 8 prohibited concepts, again, on their face, sort of look like they mean don't say racist things, but what they really mean is don't talk about racism or sexism. And so we have brought 4 specific claims against this law. One is a vagueness claim, basically saying It's impossible for teachers and school districts to figure out what on earth this law means. We brought an academic freedom claim, basically saying that this law restricts academic freedom, especially in higher education, by prohibiting even the presentation or consideration of race and sex stereotypes in any requirement, which could be any required course, any required text within a course. This is way too overbroad and viewpoint-based to survive First Amendment scrutiny. We also bring a claim under the First Amendment right to receive information on behalf of students. The First Amendment protects your right to speak. It also protects your right to receive information, and that's especially strong for students, even in the K-12 context. So we brought a claim on behalf of students for this law denying their right to receive information and an inclusive and robust comprehensive education. And we also brought an equal protection claim. And this is basically saying that this law was motivated by racial animus. And it has a racially disparate impact. It disproportionately will impact Black, Indigenous, other students of color, other marginalized folks, women, LGBTQ folks, because it's trying to silence efforts to build a more inclusive curriculum that reflects the broad range of student identities that exist in Oklahoma and indeed across the country. So I'm really excited about this case. It's front of mind because it's exactly what I'm working on right now. But I want to take a pause for a moment just to introduce myself a little bit more. So as you heard, I'm a senior staff attorney at the ACLU National Office, and I work on the Speech, Privacy, and Technology Project. I'm a First Amendment litigator. I cover the right to protest. I work on campus speech, and I also cover cases that deal with the intersection of free speech and racial justice. I have many colleagues who also work on these things. This is not uniquely my area, but this is the kinds of cases that I work on. Previously, I came to this work through a somewhat unconventional path. I actually worked on international human rights before this. As you heard, I worked for the International Center for Not-for-Profit Law, where I advocated for the freedom of association, freedom of assembly, and freedom of expression across sub-Saharan Africa. And before that, I worked for the New York City Council in their Office of the General Counsel. But let's take a step even further back than that. And I'll tell you about sort of how I became so passionate about campus speech. I think you can see, you'll let me know if you can't see my slides, but this is actually where I grew up. This is my hometown. I was born and raised on a campus. So I've been on many campuses since then, but campus life is in my blood. How did I end up growing up on this campus, this prep school campus in Massachusetts? It's because my mother and my father both worked at the school. So you have a picture here. My mom is on the left, my dad on the right. And they were educators their entire careers. My mom and my dad both were born and raised in Shreveport, Louisiana, attended segregated schools all the way through high school, and then made their way to Cambridge, Massachusetts for college. My dad first went to Dillard University in New Orleans, and then made his way to Harvard Yard. And eventually they ended up working at Phillips Academy Andover, the picture I just showed. I want to say that, it's funny in some ways that I end up talking so much about student activism, because if you ask my classmates, they wouldn't say I was the biggest activist. And if you ask my parents about their experience as students, they would not claim to have been activists. Even though it was the late 60s, there was a lot of activism happening, they didn't consider themselves activists. But having come from where they came from and being where they were, what my dad says is the most revolutionary thing I could do, being a Black kid from Shreveport, Louisiana, the most revolutionary thing I could do was go to class. And so I think, I'm going to talk a lot about what student activists can achieve and accomplish and all the ways in which the First Amendment encourages and supports their work. But I also want to take a note to say that there are many places, I would venture to say a place like Oregon, with the history of the state of Oregon, is a place where your presence can be a form of protest. Being in that faculty room, being in that department meeting, being in that class, being in that student group, just existing in that space can be its own form of protest. So I just want to name the fact that, you know, there's the time for raising fists and pulling up bullhorns. And I know that that's been done at Oregon time and time again to great effect. But there are also times when just being there says it all. And the only other thing I would just say is, you know, I have a cousin who comes from my mom's side of the family, also has his lineage is from Shreveport, Louisiana. And when we were 15 years old and I was attending Phillips Academy, that beautiful campus you just saw, he was arrested, convicted, and imprisoned for felony murder and sentenced to 35 years to life. So I'm now 38 years old. Since I was 16 years old, every step along the way, I've been thinking about my cousin Ollie, because we're almost exactly the same age. We have the same great-grandmother. And all of this time that I've been spending on campuses and all the work that I'll describe to you in the next few minutes, Ollie's been in California State Penitentiary. And so I just want to also just say that, you know, to say that your presence can be protest is not a cop-out. It's not an excuse to sit back and let things happen on your campus or in your midst. But it's just to say that it's not a foregone conclusion that we would end up in these spaces. And it's there, but for the grace of God, that we end up in very different places. But where did I actually come to some student activism? Where was the first time that Black student activism and the overwhelming impact that they can have first resonated for me? Was when I was a teenager and I went to South Africa with some very close family friends. They had been veterans of the anti-apartheid movement. They had participated in the Soweto uprisings. And when we went back to South Africa in 1997, Nelson Mandela was president. Apartheid was over. And I got to visit these streets of Soweto, where these students, if you look closely, you can see most of the people in these pictures are wearing school uniforms. They're not even university students. These are secondary school students. And they were at the front lines of the movement that eventually led to the toppling of apartheid in South Africa. They literally overturned their societal structures through the power of their protest. And so when I, years later, after finishing law school and working in a few different jobs, ended up working in international human rights, it was because I had initially been inspired by these students to understand that, yes, things can indeed change. And it's never simple. You look at South Africa today, things are very complicated, to say the least. But the one thing we know is that change is certainly possible. So I want to fast forward to a picture that's me with the even more enormous beard, but without so many gray hairs in the front. This picture was taken while I was working for the International Center for Human Rights, the job I had previous to this, where I worked with civil society activists, human rights activists, professors, teachers, all sorts of community organizers all over the continent to try to reinforce the international right to the freedom of expression, freedom of association, and freedom of assembly. These things are also enshrined in the African Charter on Human and People's Rights. And so we were trying to make sure that these lofty ideas and these international human rights documents were experienced by activists on the ground. And one of the things that I was so lucky to do was to teach a course at the University of Pretoria's Center for Human Rights. And that's a class photo from, I think, 2016 that you see there. And all of the people on those steps are graduate law students from all over sub-Saharan Africa. Almost every one of them is from a different country. And they come together in this Masters in Human Rights and Law course, and they work together and they learn together. And then they go off and do amazing things. These folks go off to run organizations, run for parliament, manage major campaigns across the continent to increase, environmental justice, women's rights, LGBT rights, all manner of disability rights. These folks are on the forefront of pushing for African human rights. And it was an inspiration to work with them and to realize that that a place like the University of Pretoria, which again, I submit has some resonance with a place like Oregon. Pretoria was the homeland of the Afrikaners. It was an institution that remained white only long after many others integrated. And even with this long history of its deep commitment to white supremacy, the University of Pretoria became the home to the Center for Human Rights, which is where the vanguard of African human rights activists are fostered. This group is so powerful and connected to each other that other people in the industry call them the mafia. That's how strong this cohort is and how powerful they have become. But it's complicated, right? Because there's a way in which these human rights documents, international human rights, I'm going to stop my screen share. There are lots of critiques of the international human rights model, right? International human rights essentially grew out of a meeting among Western powers when many countries that exist today were not even countries yet, right? They were still suffering under colonialism. So these international human rights norms have a complicated history. The project of international human rights is mostly sort of implemented in a north-south kind of way. Many of you may have worked for or looked forward to working for non-governmental organizations. They call them NGOs, right? Doing everything from advocating for human rights to digging wells to help increase access to water for people in small remote villages. You know, NGOs are doing tons of work all over the world to try to help people. I often talk about how sort of there was an NGOs 1.0, which was sort of we're going to go around the world and save people, very much sort of based on a savior complex. What we have now is a slightly more evolved version. I call it NGOs 2.0, where basically we focus on things like capacity building and small grants to seed some ideas. But fundamentally, things are still rolling downhill from north to south. It's the northern donors who establish the criteria, and the smaller grassroots organizations are left to hope that some pennies trickle down. Literally, the US government will allocate $5 billion for a project, and it will end up in an African country, for example, in small grants of $5,000 to $10,000 that are spread around. I'm not saying that these are not worthwhile efforts, but it's still a very dramatic power dynamic that's problematic. And I think everyone understands that we need an NGOs 3.0 that's truly based on equity and a sustainable model for local human rights activists to be able to promote their own activities without being dependent upon Northern donors. So at the same time as I can be very critical of sort of the neo-colonial themes within the international human rights movement, when I look into the eyes of those students at the University of Pretoria, the things that they are fighting for are not neo-colonial ideas. They're fighting for marginalized populations in their home communities so that people have the opportunity to live free and flourish. And I think, you know, when someone says, oh, these are Western values that you're trying to impose on other cultures, I understand that and I take that to heart. And when you're talking to a young African woman who says that I'm going to advocate to make sure that women and girls are able to continue their schooling this beyond primary education, that to me is not a Western ideal or even a neo-colonial idea. And I stand with that person and I want to help that activist make that happen. So as much as we can be critical of some of the roots of these things, I think there is a certain truth in the idea that everyone has the right to freedom of expression, freedom of association, freedom of assembly, as well as all of the other civil, political, and human rights that we think are bestowed in every individual just by virtue of them being a person. So I did that work, which I dreamed about doing for years and years and years, that international human rights work for about 6 years. And then I switched and I decided to join the American Civil Liberties Union. Now, when I decided to do that, it was not lost on me that I was sort of trading one critique for another. Trying to join the ACLU to work on the First Amendment is a similarly complicated undertaking. So I just want to say a few things about what it means to be an ACLU attorney. So very briefly, the ACLU has been around for 100 years. This makes it unique among organizations. And I'll say, in my work across Africa, I was working in support of nonprofit organizations. So I came in contact with every size, shape, and variety of nonprofit organization all over the continent of Africa, as well as those working all over the United States. So I've come in contact with a lot of nonprofit organizations, and none comes anywhere close to the ACLU in terms of its history, its reach. The ACLU has affiliates in all 50 states. In California, we have 3 affiliates, the Northern California, Southern California, and San Diego. So we have a nationwide reach and a ground game that's unparalleled in any organizations I've seen in any country. We also have the largest share of our donors are individual members and their small donations. We do accept foundation money and even some corporate money, I believe, though it's pretty quiet. But we're not beholden to any of these interests because the vast majority of our funding comes from our members. So I think that these unique aspects of the ACLU have contributed to its strength over the last 100 years. The other thing that's unique about the ACLU is we have our state affiliates, but then within national, we have our communications team, we have our political advocacy team, which covers both legislative advocacy and organizing. And then we have our legal department, where I am. And within the legal department, we've got a lot of different projects. We've got a women's rights project, a racial justice project, immigrants' rights, LGBT rights, all sorts of disability rights. We have a lot of different thematic projects, of which I work on one, which is speech, privacy, and technology. So we cover so many different issues. We overlap with lots of different organizations on different issues. We work with Planned Parenthood on reproductive freedom. We work with the NAACP on racial justice. We might even work with some libertarian organizations on the First Amendment, but nobody kind of covers all of these different issues with the comprehensiveness that we do. But with that, the ACLU is also known for taking controversial cases. I just mentioned how we're sort of reliant on our donors. There have been several points in the ACLU history where we have pissed off so many donors that we've lost tons of them, including when we take controversial First Amendment cases. So when I joined the ACLU, people said, oh my goodness, you know who they represent, right? And I said, yeah, I know, but they have a principled position. We'll figure out how to do it. We'll figure out how to navigate it. And one of the things that I had the pleasure of doing soon after I joined the ACLU was getting to interview Eleanor Holmes Norton. So Eleanor Holmes Norton is currently, and has been for decades now, the representative in the House of Representatives for Washington, D.C., for the District of Columbia. She was the deputy legal director of the ACLU right out of college in the 60s. As a young Black woman and one of 2 attorneys at the ACLU's national office, at that time, we had a structure whereby we used what we called cooperating attorneys much more than we did then. Our central staff was not big, but we had a lot of cases going on all over the country. But Eleanor Holmes Norton was one of 2 attorneys here in the New York office, along with the legal director. And she took a broad variety of cases. And then they didn't have projects focused on all sorts of different things. When I told her that I focused on the First Amendment, she kind of said, well, what does everybody else do? So she told me stories about what it was like to defend all manner of folks and their First Amendment rights. She told me, her friends in the civil rights organizations, in SNCC, in the students, in all of the different student-led organizations that were fighting for civil rights, they told her, how can you defend the rights of these white supremacists to spew their hatred? And she said, look, I understood that what was going to be created out of this case law was going to be used against the civil rights movement. And her friends told her, what's good for the goose is not going to taste the same on gander. And she understood this very clearly, but she also knew that these were the cases that were going to establish the rules for how a government can restrict views and speech that it doesn't like. And she understood that there was great value in restricting the government's authority to determine what is okay to say and what is not okay to say. So learning from her and sort of heartened by this, I sort of have dove into this work as a First Amendment litigator. And before we go further, I just want to take a second, again, allow me to spend just a moment with the text. Okay, so let's actually look at the First Amendment. Congress, it's not long, so I'll just read it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Okay, so let's break it down a little bit. The very first word in the First Amendment is Congress. Now, if I showed you the international human rights documents, the first word is everyone, right? Everyone has the right to freedom of speech. Everyone has the right to freedom of assembly. Everyone has the right to freedom of association. But the First Amendment says Congress shall make no law respecting 5 different issues, 5 different freedoms. So I'll hammer this point over and over again, but the First Amendment is about restricting the government's authority to regulate speech. It really doesn't actually say that what you have the freedom to do. It says this is what the government cannot limit. And so the First Amendment, that's why the First Amendment doesn't apply to Facebook or Twitter or other private entities, because they're not the state. Congress really means the state. And even it can mean a public university. So for First Amendment purposes, the University of Oregon is the state or Congress, and they're not allowed to violate people's First Amendment rights. The First Amendment is about restricting the government's ability to regulate private speech. In which regard? Congress shall make no law respecting an establishment of religion. So there's a poetry to how the 5 different enumerated freedoms are ordered. And this is something that Bert Newborn, one of the legends of the ACLU and my alma mater, NYU Law, has talked about. There's a poetry, there's a reasoning behind the ordering of these freedoms. And it gives us insight into what we can glean from the First Amendment. So the government can't regulate your religion, right? So that's what you believe, your thoughts, your ideas, your faith. Next is it can't abridge the freedom of speech. So now you've gone from having an idea, a belief, a faith system, to communicating that idea or belief. Now you're speaking, you're communicating with others, and the government can't regulate that either. Or of the press. So now we've gone from an idea to speaking that idea to those who are within close range, to the press. Now, I mean, we're talking about publishing. We're talking about disseminating to a wider audience. Now, literally then they were talking about a printing press. Now we talk about other forms of disseminating ideas in a wide way. But basically we're talking about the journey from an idea to words, to published words, and then the right of the people peaceably to assemble. So now you're not just thinking something or saying something or writing something and publishing something, you're gathering people around this idea. People are coming together, they're mobilizing, they're feeling solidarity, and they're physically sharing space. And to petition the government for a redress of grievances. So you have the right to not only have this idea, not only speak this idea, not only publish this idea, not only galvanize people around this idea, but bring this idea just to the foot of government for consideration to redress your grievances. So in this way, I think we can understand the First Amendment when we look closely at its texts about facilitating this journey from an idea to a movement. And of course, you know, this is a complicated few words, but I want to leave you with a few key thoughts. So some of the key terms that you might hear thrown around the First Amendment. There's not a whole lot in the text that gives us much guidance in terms of real world practicality. How do we apply this? But one of a few key ideas. One is content and viewpoint-based regulations versus time, place, and manner regulations. So you may have heard about this, but basically content and viewpoint-based regulations are almost never allowed. The government has to prove a lot in order to get away with regulating speech based on its content, and even worse, on its viewpoint. But the government can regulate the time, place, and manner. So for example, the government can say, for example, without violating the First Amendment, you can't have, if you want to use loudspeakers in a residential neighborhood before 7 a.m., you need to get a permit, right? So they're regulating the time, place, and manner of speech. At a certain time, in a certain place, if you want to use a certain kind of amplification, you got to get a permit, right? That would be potentially a valid time, place, and manner regulation. But what you can't say is, you're not allowed to protest against abortion, or you're not allowed to protest against the police, right? That would be a content or viewpoint-based regulation. And we just don't trust the government to make those kind of calls. They're not allowed to discriminate based on viewpoint or content. The government can speak out on its own behalf. The government can have its own views, but it cannot discriminate based on viewpoint among private speakers. We often say that, the First Amendment has the most robust protections for free speech of any society in the world. Maybe an overstatement, but it's pretty close to true. But not all speech, even under the First Amendment, is protected. There are categories of unprotected speech. So you may have heard some of these: defamation, true threats, fighting words, obscenity, harassment, incitement. I've written a bit on incitement and how it relates to efforts to crack down on the right to protest. These might seem like sort of vague terms, but within our legal system, they've been defined very narrowly, much more narrowly than in other jurisdictions. So in order to prove defamation, you've got to show quite a bit, right? In order to prove incitement, you don't just have to say, oh, he said something and then they did something. You've got to show that they intentionally directed someone to imminent violence or violations of the law, and it was objectively likely that the speech would lead to that violation of the law or breach of the peace, right? So you've got to have three elements. You've got to have intent, you've got to have likelihood, and you've got to have imminence in order to prove incitement. It's a very high bar. And that's true of all of these categories for unprotected speech. For harassment, that's one that comes up a lot. And I know one that's on the minds of a lot of people on campus because of the targeting of certain professors on Twitter and elsewhere. But in order to prove harassment under the First Amendment, it's got to be targeted, it's got to be repeated, and some generalized statements do not meet the bar for harassment. But targeted, repeated harassment, of course, is not protected by the First Amendment. What you'll notice on this list of unprotected speeches, hate speech is not a category in US law. Sometimes you'll hear people say, oh, but that's hate speech, that doesn't count. But if you look up to the first bullet, you'll realize that the reason that we don't prohibit quote unquote hate speech in our system is because we don't actually trust the government to determine what is and what is not hate speech. And if that doesn't make sense, then just think about how attorney Jeff Sessions said that he considered Black Lives Matter to be a domestic terrorist organization. We actually don't want the government to have the authority to say what you can and can't do. Of course, if you break the law, if you're smashing windows, if you're stealing things, if you're destructing property, those things can all be prosecuted as violations of the law. But what we don't want is for the government to be able to say, we don't like what we're saying, and therefore you're not allowed to say that anymore. What does this look like on campuses? You know better than I do, but I work with a lot of folks on a lot of campuses. And the key themes that I want to just highlight are that, we talked about this a little bit, but public and private universities have different stances under the First Amendment. The University of Oklahoma is a public university. It is the government for the purposes of the First Amendment. Many private universities also sort of are committed to the principles of free speech and commit themselves to at least as many protections as are protected under the First Amendment. But strictly speaking, private universities are not bound by the First Amendment because they can't, even if a private university limited speech, it would not be government censorship. And we look on private censorship in a different way. So, for example, religiously affiliated universities can regulate speech on their campus in a way that a public university cannot. Another key point around campus speech to keep in mind is that the rules are different for college and K-12. In K-12, we have a long line of cases from Mary Beth Tinker to the recent Mahanoy case, which my colleagues here who actually share this office won recently at the Supreme Court. This was the fuck cheer case, where a student sent a Snapchat on the weekend to some friends saying fuck cheer, fuck softball, fuck everything, and was then suspended from the softball team for a year. And what the Supreme Court said, in an admittedly messy opinion, is that this didn't cause any disruption. There's no even plausible allegation that this Snapchat disrupted in any way the school community. It wasn't a threat. It wasn't harassment. It wasn't any of these prohibited categories of speech. On the weekend, kids get to be kids. And that was a big win for student speech rights. But in college, the rules are different. We protect free speech more robustly in colleges than almost anywhere else, which is great news for intellectual vibrancy. But it also means that college students have it really rough. And I don't need to tell the college students on this call, but the unique nature of campuses. As I said, I love campuses. I was born on a campus. I've lived on lots and lots of campuses. I've visited campuses. I wish I could be on your campus right now. But it's a treacherous place. It's where you eat. It's where you sleep. It's where you study. It's where you work. It might also be where you teach. I spoke with several grad students today who are teachers, students, staff members, residents, family supporters, and activists, right? And all of that is happening literally within a 3-block radius. And so there's a way in which what we ask college students and other members of academic communities to put up with is unlike anything that any of us put up with outside of the campus context. I don't have to eat across the table from my political opponents. I don't have to look at their posters as I walk to the bathroom. So I just want to sort of highlight the fact that I'm very conscious of the fact that when we say that there are robust protections for free speech on campus, I think there's good reason for that, but it makes it extremely difficult. And I think too often people overlook how difficult a position it does put students in. So what have we done to address this? What we've seen time and time again is something happens on campus, some kind of racialized, gender-related, some kind of hateful incident happens on campus. Students are up in arms, faculty are up in arms, community members are alarmed, they're hurt. The university is obligated to respond, often with some inordinate delay, and often with some sort of statement like, this doesn't reflect our values, when in fact, quite literally, it does reflect what's going on in the community. And then basically the administration would often throw up their hands at different universities and say, there's nothing we can do, freedom of speech. And of course, this would leave students and other community members feeling unheard, unwelcome, unsafe, and excluded. And so we were trying to figure out, look, the answer for us is not to throw out the First Amendment. The answer for us is to figure out how we can get across this blockage to have real community engagement around what it means to really protect free speech and what it means to create an inclusive community. So we've been working with student activists, focusing on California. We've been partnering with the University of California National Center on Free Speech and Civic Engagement, housed at UC Irvine. We worked together to develop a curriculum for student activists on their free speech rights. Basically, we were seeing, as everyone has seen, young people are questioning everything about this country in a beautiful way. Why aren't we being more active about climate? Why are we committed to letting guns be in all these public places? Why have we ignored the histories and the narratives of so many of our community members in our official curricula and our official, our understanding of our own national mythology? And also, why are we so blindly committed to this principle of free speech, even though it can hurt people? And so this workshop is designed to engage in depth with student activists around this question and to make the affirmative case that we need to fight with all our energy against these problems that we see in our society, and that without the protections in the First Amendment, we don't have a chance. We don't have a chance. If we don't have the space to advocate for social change, to disagree with those in power, then we don't have a chance. So we've been preaching this message at campuses across California, at Berkeley, at UC San Diego. We've been working with our partners at the ACLU of San Diego and the ACLU of Northern California. And we're really proud of the number of students that we've been able to engage with, and we hope to bring it to lots more campuses in the future. But it's not just about training. As I said, I'm a litigator. My job is to bring cases like the case in Oklahoma. But there's another thing that we also do at the ACLU, which is a little bit unique, which is we write a lot of what's called amicus briefs. And so an amicus brief, a little technical, but an amicus brief is where somebody who's not either the plaintiff or the defendant, they're not directly involved in the case, but they have some sort of expertise, and they write what's called a friend of the court brief. And they say, look, we are not a part of this dispute, but we think the court should consider this perspective. And because the ACLU has been around for 100 years, because we've been litigating at every level, from state court to federal court to the Supreme Court, we have some sway. When we choose to weigh in on a case, sometimes we can have influence. We don't always win, but it's worthwhile for us sometimes to weigh in, even when it's not our particular case. So sometimes we decide, there's enough of an important principle at play, especially around the First Amendment where I work, that we're going to weigh in with an amicus brief. And I just want to tell you one more story about a case that I worked on with some student activists in Arkansas. So this is a student group at Arkansas State University called Peace and Love, which, how can you not love these folks when their name is called Peace and Love? So what was going on at Arkansas State is they had a rule, a policy on campus that established what they called free speech zones. Now, under the First Amendment, free speech zone is not really a thing, right? This is something that they created in order to say, okay, this part of campus is for protesting, and this part of campus, if you want to set up a table, you need a permit. If this part of campus, if you want to set up a table, you need 24-hour notice. And keep in mind, these are all public spaces around campus. Now, how to regulate walkways and entryways and all those sorts of things in plazas is something that every campus I've ever been on has had to navigate. But what they were basically saying is, you only have First Amendment rights within the square footage that we say so, and under the conditions that we say so. And so basically, even to use the free speech zone, you needed to get approval from the administration, right? So this was something that the ACLU of Arkansas had been railing against for years, saying this is not a constitutional policy. You can't limit free speech on a college campus to a few square feet way out of the way in order to make sure that people don't have to listen to protesters. Right? That's not our vision of the wide open type of dialogue and civic engagement and promoting the next generation of leaders that we want to see on a college campus. So a year and a half, 2 years ago, a student representing Turning Points USA, which some of you may be familiar with Turning Points USA. It's sort of the Trump wing of the Republican Party, the youth wing. Someone from Turning Points USA showed up at Arkansas State and without a permit tried to set up a table and get signatures for people to sign up for a new chapter of Turning Points USA on campus. Maybe it goes without saying, but I'll go ahead and say it. I'm no fan of Turning Points USA. And I'm no fan, especially of the organization that decided to be their legal counsel, which is basically on the other side of so many ACLU issues. But in this case, decided to take this First Amendment case on behalf of Turning Points USA. And this organization reached out to the ACLU and said, hey, do you want to weigh in on this case? We noticed that you've been against this policy for a long time. This policy was just enforced against Turning Points USA. They said that they violated the free speech zone policy, and we're going to sue. Do you want to get involved? And so we had some internal discussions, and we said, what are we going to do? We don't like this policy. A federal court is now going to look at this policy. Are we going to be quiet about it? Are we going to sit back and say, well, we don't like Turning Points USA, so we're going to sit this one out? Or are we going to weigh in to say that this policy, which we've been saying for years is unconstitutional, is in fact unconstitutional, even though it was used in this case against someone with whom we have a very, very, very long list of disagreements and concerns? So what did we do? One of the things that's unique about being an amicus or a friend of the court is you can also represent a different party. So we decided to file our amicus brief in this case on behalf of Peace and Love, because they had also faced problems with this policy, having rallies, having protests, having sign-up events, having to get 24 hours pre-approval before they can set up a table. So we were able to write a brief to the court that said, look, we do not support in any way the content or the viewpoints expressed by the plaintiff in this case. But this court should know that this policy is unconstitutional, and it's been used against our clients and countless others on campus, and you should strike it down. Now, the university subsequently withdrew the policy, so the case sort of went in a surprising direction. But I think it illustrates the ways in which, we weigh in when we think the principle involved is important enough, even if it means directly or indirectly supporting speech with which we directly disagree. Now, in this case, we actually didn't end up having to represent Turning Points USA. It's much more complicated if you become someone's attorney, because then it is your ethical obligation to do everything you can within the bounds of ethics and the law for them to win. You can't throw them under the bus and say, I don't agree with them, but they have constitutional rights. That's not ethical representation, right? So when you take someone on as a client, you have much more obligation to actually look out for all of their interests, not just a narrow constitutional rule. But when you can weigh in as an amicus, of course, it's often less effective than bringing a case directly, but allows you to say, look, the facts of this case are unappealing in all sorts of ways, but don't lose sight of the very important principle that's involved. And I think that's a through line for our work, and that's a theme for the ACLU, which is, we agree with a lot of folks on a lot of things, but in many, many situations, it's our role to say, look, we agree, but be careful. The thing that you're asking for might have some unintended consequences. So I'm looking at the time, and I want to just finish up with a few helpful tips that I call sort of do's and don'ts when we talk about the First Amendment. So First Amendment do's and don'ts. First, I'll give you my list of don'ts. These are things, I am a First Amendment litigator. I've just spent almost an hour telling you all the reasons that you should believe in free speech and the value of the First Amendment. But there are lots of arguments in favor of the First Amendment that I think are totally bogus, and I never use. First, you might recognize that picture in the corner, it's at least supposedly a showing of the founding fathers with red dots on all of the ones that were slaveholders. There's been some dispute about the exact accuracy of the count or whatever. But the point is, anytime you start a conversation about free speech with, well, it's the First Amendment of the Constitution. It was a founding principle of our country, sort of directly or indirectly pointing to the immaculate wisdom of our founding fathers is one of the worst First Amendment arguments. The reason I do this work is not because a bunch of old white dudes from a long time ago, many of whom owned slaves, said it was a good idea. It's because I've seen that the only way to bring about change is if you create space for people to voice their concerns. And you limit the government's ability to silence and censor them. Another terrible argument for free speech is some version of kids these days. They're snowflakes, they don't get it, they can't listen to ideas they disagree with, they think everything is violence. But I think what this fails to recognize is that, one, if you don't teach civics in K-12 education, how are you going to expect people to know civics in K-12 education? But also, even and more fundamentally, there was no better time before. People often sort of say kids these days don't understand what's the sacrifices needed from democracy, because supposedly in some previous period, people had a better understanding of that. And I think that's a total misreading of our history. To the extent that that has any weight, it's because the academy and other spaces were so excluded before that now that you have more people allowed to enter these spaces, you're going to have to renegotiate terms of engagement. But I reject any idea that things were better before. And the last idea that I don't rely on is this idea of the marketplace of ideas. Now, I'll admit, courts use this terminology occasionally. It creeps into some of my briefs, but I don't like it. You see, the joke here is just how fresh are these insights? We shouldn't, the idea behind the marketplace of ideas is you just got to let as much speech and just let everybody talk, and inevitably somehow the right ideas will win out in the end. Truth and justice will emerge from the invisible hand, like the invisible hand that guides the markets. But just like I don't trust the marketplace of goods to yield just or truthful results, I don't trust the marketplace of ideas to inevitably lead to some more enlightened place. You know, there are structural inequalities. The playing field is not even to begin with. There are not inherent, but there are pre-existing power dynamics that affect people's ability to spread their ideas. Of course, social media and other technologies have allowed for a dramatic democratization on who can reach a broad audience, but still, power and money matter in terms of how much of a voice you have. So this idea of the marketplace where everything will just work itself out, I think is a misreading of how marketplaces work, and also doesn't really apply to speech. So what do I rely on when I talk about free speech? First, I start with the idea that it's a universal human right. We start with equality. Everyone has the right to freedom of speech, freedom of association, freedom of assembly. And if we start from that place, if we start by recognizing that we all start with equal rights, that can be a revolutionary place to start, but it can also be a very comfortable place to plant our feet. The second thing I always talk about when I talk about the First Amendment is that it's really about fighting the power. And the ACLU has been standing up for this principle of not trusting authority for 100 years. And this sort of resonates on the left, the right, and the center. We don't trust the government to decide what ideas are okay and what ideas are not, because inevitably they will not allow criticism of that same government. And that stifles progress. If you want to change the country, you've got to be allowed to disagree with the people in power. So you've got to limit their power to censor you. So fundamental to any understanding of why the First Amendment is important is the impulse to distrust authority. And the last thing I would say is, when it comes to thinking about free speech, I think we all got to remember that we can change our minds. I mean, in a deeply polarized time, it's hard for us to think about someone sort of switching sides in any debate, but all of us have changed our mind. And if you're not willing to admit that, maybe you know someone who's changed their mind about something really important. So people can change. I'm not trying to be idealistic or say that, you know, you can talk someone out of the KKK or that you should have to. But all I'm saying is that it's important to keep in mind that just like people are not the worst thing that they ever did, people are also not the worst thing they ever said or the worst thing they ever thought. So if I believe in prison abolition, if I want to get my cousin Ollie home, if I think that sending people into prison is not the way to heal victims and engender real accountability that leads to growth. If I believe, I have 2 little kids, if I believe that the best thing I can do when they do something hurtful to their sibling is for them to acknowledge the pain that they've caused, to understand the impact of their actions, and to figure out a way to make it better, instead of just sending them to their room. If I believe in those principles of restorative practices, then I also have to believe that we can forgive people for things that they've said. Now, that doesn't mean that we don't call them out when they're wrong. I am a huge, huge proponent of calling out. I believe that it is the epitome of free speech. I believe that the right to protest is fundamental, and that's why I've devoted my life to it. But at the same time, I do have pause when we talk about canceling, in as much as, not to weigh into this whole whether it exists or not, but to the extent that people on all sides reach to the most punitive measure available when they see things that they don't like, and they want to sort of excommunicate people for disagreeing with them. It makes me think about, how can we be prison abolitionists? How can we believe in restorative justice and not deeply engage with the idea that we have to find a way to show that we care about something without immediately reaching for punitive measures? Now, restorative justice doesn't mean you let it go or you forget about it or that it's not important. It means that you prioritize making victims whole and you prioritize real accountability. And you don't resort to the easy mechanism of, oh, send this person away, make these ideas go away. I don't want to see this. I don't want to listen to this. And I think it plays out on campuses as well. You know, what if so many times our demand is, when something happens, our feelings are valid. And we want revenge, we want punishment. But I submit that between doing nothing, throwing up our hands and saying it's the First Amendment, there's nothing we can do, and excommunicating people from our community because of what they've said or thought, are all the good ideas for how communities can heal and grow and prosper together. I'll stop there, but I look forward to your questions, and I really appreciate the opportunity to speak with you today.
Wow. Emerson, thank you. Thank you so much for that nuance and complex explanation and overview of the First Amendment, especially the personal reflection and the ways in which you took us basically around the globe. So we're going to give you a few seconds, just a few seconds to catch your breath, get some water. And I am going to remind our colleagues and all of our guests who were kind enough to stay on and listen that now is the time to ask questions. All right, I'm going to begin with the question as we fill the question and answer box here. First, just a comment and then a question. What particularly resonated with me was one of the statements that you made early on about the most revolutionary thing you can do is go to class or show up for the faculty meeting or engage. And I think that sometimes when we are in the midst of a fight, in the midst of transforming institutions and sort of being in that milieu that is so problematic, that we forget that the very act of showing up is revolutionary, is part of the transformation. And which comes the question, that also has an impact on the bodies of the people who actually show up and are on the front line. And your talk also helped us to understand that First Amendment has consequences, right? The impact of that. So what are some of the practices that you recommend or that you've seen campuses engaged in to actually deal with that social, emotional, physical, mental health impact of environments where the kinds of free speech consequences have a negative impact on minoritized communities and minoritized individuals?
Thank you so much for the question. I mean, I think it's true that this is something that every campus wrestles with, and sort of how do we address these underlying issues, these community issues? As I often say, as I said to several of your colleagues today, when these issues come up, I mean, it sounds silly for me as a First Amendment litigator to say it, but sometimes we've got to put the First Amendment to the back of our minds and just be community members and listen, right? And even if somebody's demands might not be possible, either because they're not feasible or because they would actually violate the First Amendment, that doesn't mean we shouldn't hear them out and also understand that there's usually a lot going on behind whatever the issue is that's right at hand. Right? So this gets to your question about sort of what are the underlying things, because if an incident happens, invariably, it always, whenever I start talking to people about something that happened on campus, some sort of protest, some sort of incident, some sort of comment, they also start bringing up, and then last semester, something similar happened, and the year before, and 10 years ago, and in the founding of the state of Oregon. You know, people, there's history, there's baggage that comes into all of these incidents. So acknowledging that if someone's coming to you with a complaint, chances are it's an accumulation of things. So you can't just deal with the one thing that's in front of you. And you can't just limit yourself to saying yes or no to their demands. Engaging in a much deeper way involves the kinds of things that I think University of Oregon has done. And I, again, credit to the Black Student Task Force for creating things like this workshop, for the founding of the BCC, for all of these ways in which people can feel supported, included, represented, and have literal physical spaces to share and to deal with what it means to be sort of in a minority in a predominantly white institution or historically predominantly white institution. So I think University of Oregon is doing a lot of those things. They're not easy things to do. They don't have quick results. And one thing that I also was talking with your colleagues about is just because you open, like, I think it's great, but I think sometimes administrators are also like, but we opened the BCC, why are you still complaining? and it's ongoing work, right? Like in some ways it can be thankless work even, but it's because student activists will never allow people to rest, because there's always another battle. And I think you just have to accept the fact that you don't get to sort of rest on your laurels. I applaud the University of Oregon for the progress that it's made, but don't expect anybody to let up. I think you're muted.
I'm muted. Thank you so much. So now let's go to some of the questions that are coming in. So one of the questions is about our school board members. And I think you've talked about the ways in which these kinds of issues are occurring across the nation. So I'll just read it. Minoritized school board members and school district officials are experiencing intimidation from organized protests against racial and gender inequities in K-12 classrooms. What advice do you have for BIPOC communities and allies to support the schools?
My goodness, I think I told you this story, Yvette, but this hits home, right? Because yes, I just have to tell you. So yesterday, I spent much of the day preparing for this lecture, preparing for the meetings with the different folks on campus. And I was also preparing a brief for that Oklahoma case I mentioned, which is about this inclusive education ban. And as I came home, I was finally, done for the day, I got a text from my kid's teacher saying, join the PTA meeting. We've got one of these anti-CRT parents in here co-opting the diversity committee meeting. So then I end up signing into this Zoom on my off time where someone is like, bringing up all of these anti-CRT arguments in my own kid's PTA in Brooklyn, New York, not a red state. So yes, this is hitting on every level, on the national level, on the state level, on the school district level, on the school level, on the personal level. So I totally empathize with anyone who's facing this in their work. In terms of what school board members can do, I mean, I think, this is not my area of expertise, but I think, part of what I think the African American Policy Forum, which is headed by Kim Crenshaw, who is one of the founders of critical race theory and sort of coined the phrase intersectionality. AAPF has been organizing a national campaign, including communications, educators, artists, and yes, litigators as well, but only one of many different kinds of organizations, coalitions that they're bringing together. And lots of folks all over the country are trying to figure out how we can be supportive of each other. So there are resources out there. There is solidarity. I know that people might feel isolated when they're in some random school board meeting, but this is happening across the country, and there are a lot of folks trying to get organized. So I encourage you to check out AAPF and also look for other resources to gain solidarity. There are some best practices. The National Education Association has come out with some good guidance on how to navigate these things. But it's a real challenge. It's a real challenge. And I think one of the things we need to do is emphasize the positive value of inclusive education. We need to reinforce the idea that whatever people might be painting with the brush of CRT, what we're really talking about is making sure that we have culturally responsive curricula that recognize a variety of perspectives, that integrate the narratives of a variety of different ethnic groups and backgrounds into the story of the United States and into world history as well. And it's not such a revolutionary idea. Really, what we're just trying to do is improve the quality of education. It's not about indoctrination or any of that. And I think the other thing we can point out, in addition to the positive value of inclusive education, is how misguided these bans are. Like I said, they are often very poorly drafted and vaguely worded, which is a due process violation. They often infringe on academic freedom, which also exists in K-12, not necessarily as strongly, but it also exists in K-12 education. It infringes on the student's right to receive information. And in many cases, there are equal protection claims too. But especially where freedom of speech has been more associated now as like a conservative value, pointing out how antithetical these policies and bans are to the principles that many folks claim who are proponents actually claim to hold dear is another potential avenue of attack. But I empathize, and I can only say Godspeed. I know that it's very difficult to confront these types of things in all of these different fora.
Thank you, Emerson. So we go from a very tactical question to one that's more philosophical. And this colleague is asking how you create or define right or wrong. So that's a sort of philosophical question. I'll give you that one. And then we go from that one to one that's offering help from a specific linguistic point of view. So we'll get to that one next. Okay.
How do I define right and wrong? That's a great question. I don't have a great answer to that one. I will say though that, this relates to what we're talking about though, because, I can have my subjective right and wrong. I believe in what I'm believing in. I'm a proponent of these things because I think that there are problems in our society. There are people who are suffering unnecessarily, and we need to change things. And the only way to change things is if we have some space to disagree with those who are currently in power. I know I've said that several times, but that's really the fundamental principle for me. So in as much as I think that's right or wrong, that's just what I believe. And so that's what I'm acting on. But it does get to the question of, we also don't want the government to be able to prescribe what is right and what is wrong and what is acceptable and what is not acceptable. So the subjectivity of the question really speaks to why we want to limit the government's authority to make that kind of call. I hope I'm understanding the question. I saw maybe a clarify. I'm not following the chat, but.
No, I think you did, and let's go to the next question that's offering you some assistance and support. So thank you so much for this comprehensive talk. As a linguist, I'm wondering about the intersection of linguistics with law and human rights. It is true that the linguistic prejudice is one of the most unanswered forms of discrimination. I know a bit about African-American English and court transcribers in the courtroom, but I am thinking more specifically with your work with freedom of speech. Have you considered collaborations with linguists in this effort?
It's a great point. We should. Whoever posed that question, please reach out. I'm interested in discussing this more. I do think that in addition to linguists, who can, I think, have some insights on the content and structures of speech, a lot more work has been done with social psychologists and others who are finding ways to sort of quantify and describe the impact of speech. We always say, sticks and stones don't break our bones, will break our bones, the words can never hurt. And what we know is that words can hurt, even physically hurt. The ways in which trauma can be passed down from generations, the ways in which, we know much more and every day about the ways in which mental, emotional harm can actually manifest in as real ways as other types of physical things. So I think there is a lot of room for lawyers to learn from other disciplines. And I think there's a way that many of us have been trying to integrate that work into our work. I still think the First Amendment is worth defending, but I think finding clearer ways of acknowledging and recognizing and rectifying the harm that comes from words is also an important endeavor.
Yes, Emerson, and what we also get from you is the importance of using our words and not just being bystanders. And so this next question is really about that and getting your advice on how to do that effectively. So the question reads, similar to the social emotional support question in our campus culture of, quote, nice, unquote, how do we raise issues in a way that we are heard and yet not targeted as, quote, negative, troublemaking, difficult, unquote, or quote, not nice, not supporting the team when we call out or are calling in issues?
It's a good question. This is when I like to say, I'm the lawyer. I'm not the activist strategist. Everybody's got to make a call about the best method of engagement in any particular situation. Sometimes maybe the best method is to stand on the table and scream. Sometimes maybe it's to whisper in somebody's ear. Sometimes it's to storm out. I can't say what's the best strategy in any given situation. But what I can say is part of what I'm trying to do is make sure that student activists in particular understand the sort of constitutional rules of the road and which parts of them are problematic and which parts of them are worth preserving. And then if they choose to come right up to that line or even cross that line, they should do so knowing. Civil disobedience, purposefully breaking the law to make a moral or legal or political point has a long and effective history in the United States and worldwide. So there is a time and place for breaking the rules. I'm just trying to make sure people know what the rules are. But at the same time, there are lots and lots and lots and lots and lots of different ways that people can advocate, and any successful movement is going to involve a broad variety. And I think, the other thing that the question makes me think of is, what should I say versus what do I have the right to say? And often people will say, you can't say that, you can't criticize me, it's exercising my freedom of speech. And I think, you have the right to say a lot of things, but whether it's strategically advantageous or kind or considerate or effective to your ultimate goal is a whole nother set of questions that has almost nothing to do with the First Amendment or the right to free speech.
And that response brings us back to this notion of community that you keep talking about, that we shouldn't just prop up the First Amendment as a shield and say, we can't really deal with this. But actually, we are concerned about something broader than that as a community of scholars and learners. So this next question is about this notion of academic freedom, and it comes from colleague Michael Dreiling, who signs the question that way as a way for making sure that you understand who he is when he reaches out. The question reads, thank you, Emerson. I'm a faculty member in sociology, longtime activist, and now co-editor for the Journal of Academic Freedom with AAUP. First, could you speak to the link between First Amendment and academic freedom, especially relating to the importance of forming truthful rebuttals to the counterfeit CRT claims? And second, would you consider contributing to the journal on this topic? If so, we'd love to talk offline.
I appreciate the invitation. I know about the journal, and let's definitely talk offline. AAUP. So I mentioned the Oklahoma case, and I mentioned one of our plaintiffs was the Black Emergency Response Team. We have several other plaintiffs in that case, including the AAUP, American Association of University Professors chapter at OU. So we're representing professors. We're representing students. We're also representing K-12 teachers. We're representing K-12 students, the NAACP of Oklahoma, and the American Indian Movement of Oklahoma. I may be leaving one out, but I think that's all of them. But we have, as I mentioned, specific claims around academic freedom on behalf of primarily the AAUP chapter at Oklahoma University. And basically what the First Amendment has recognized that there are special protections for the college classroom, right? And the college environment more broadly. That we want to make sure that these places, which were created with the idea of spreading knowledge and creating new knowledge and challenging ideas and engaging in robust debates, we want to make sure that any restrictions on speech in a college environment meet an even stricter standard than how we evaluate those types of restrictions in other contexts. So I think, as I mentioned, there's a downside to this in terms of the weight of living in this type of politically charged environment. But I think there's good reason for our democratic society to want to protect the rights of scholars to explore new ideas without fear of repression. I mean, I've lived in countries where scholars get imprisoned. I've lived in lots of places where activists, my friends, my colleagues, human rights activists all over sub-Saharan Africa getting arrested for disagreeing with the government, getting arrested for calling the government, the president an idiot on Facebook. These things are actually happening. And so when you see what happens when there's no academic freedom, it really comes home why it's so worth protecting. That said, we thought it was important not to bring the case in Oklahoma just on behalf of the professors, even though that's in many ways the strongest First Amendment claim. It's not just about professors, these tenured folks who, by any definition, whatever their identity, have some level of privilege, right? When we talk about academic freedom, when we talk about the campus community, we're not just talking about faculty. We're not just talking about tenured professors. But so many folks wear different hats, as I mentioned, I think, before. They're students, they're TAs, they do trainings for their student groups, for their faculty associations, for their departments. Folks, the campus communities are so interconnected and interwoven in so many different ways that we think it's important not to solely just focus on professors and their right to write whatever book they want, because that's important. We protect that right, we value that right, but also it's far beyond just the impact on a few sort of elite thinkers.
Well, we are 3 minutes away from the end time, and we have lots more questions that have been posed, which show, right, how interesting and important your talk is. I'm just going to ask one more question, and then our provost will close this out. And that final question is about social media internet companies who aren't liable for what's posted on them. What are your thoughts on the future of regulation of speech on social media platforms? What ought those to be?
That is not a 3-minute question, but
not 2 minutes. Actually,
no, I'll say honestly, the real answer to that question is that it's complicated. I mean, the ACLU has a very nuanced position on this. And I think, there are a lot of folks who are calling for the repeal of Section 230 to hold internet companies and platforms directly responsible for the speech that's held. I think, again, we have to acknowledge the actual harm that's coming from these the sort of current approach being taken by these major platforms. I think it is worth noting that really when we're talking about this, we're only talking about maybe 3 or 4 companies or 3 or 4 major platforms that actually can influence the sort of state of play of speech. If there's some sort of app that 15 people are on, no one's going to care about what they put on it or don't put on it, right? It's only these really large national global companies that we're really talking about. And the question is, at what point are these private actors becoming like infrastructure where they can be regulated as if they are the government, right? There's this sort of doctrine around private roads. You can build a road through a neighborhood, but in some sense, it becomes like a public road for all intents and purposes in many ways, even if it's privately owned. If everybody treats it as a road and you use it as a road and you open it as a road, then you can sort of, in some cases, be regulated as if you were the government, right? And there's all sorts of there's a whole long line of cases about, well, who is a state actor and who is not. And so essentially the question is, at what point have some or many of these specific platforms become so integral to how we communicate that they can be regulated as if they were the government? And then when and how we reach that particular line, I think is in the eye of the beholder to some extent. I will acknowledge that, folks who are active in this, the ACLU, the Electronic Freedom Foundation, EFF, even internally, there's disagreement about how close we are to that line or whether we pass that line. So it's complicated. I think the ACLU has a pretty nuanced position on this. It's not particularly in my portfolio. It's relevant to my work, but it's not the specific thing I focus on. But I would definitely point you to my colleague Vera Edelman's writing on this, and also the work of EFF.
Thank you for that. We could go on and on, because then it's the relationship between anonymous speech and accountable speech. And is that actually the major corrosive factor here rather than free speech per se, and so on and so on. You've given us so much this evening. I hope everybody takes this back into their own homes and continues these conversations, brings it back into the classroom. And you've contributed hugely to, as you've already highlighted in your work in Oklahoma, clearly exemplifies. This is what universities do. They encourage this dialogue, this discussion, and the free exchange of ideas is core to our values as a university, for sure, at the University of Oregon. So I can't thank you enough. I actually want to express my regrets that President Schill is away at a university meeting. This is literally his favorite topic, so he would have been quizzing you like nobody's business. So thank you again. Thank you, Vice President Alex Ascenso and your whole team for bringing this together, Kelly and Angeli, who helped behind the scenes. And thanks to the whole audience for being with us this evening. We really appreciate it.
Thank you so much.
Bye-bye.
Good night, everybody.
Good night.